comment portion of the meeting will be after Mr. Wozniak does his presentation, and after the board has answered questions, and not just the board, but planning commission and ZBA. That being said, planning commission.
Commissioners, I'd like to call to order this special meeting of the Webster Township Planning Commission. Thank you all for attending. ZBA.
ZBA, we'd like to call this meeting together in order. Just a training meeting, so thanks for everybody showing up. A couple are missing.
There's just one.
What?
Oh, three, sorry.
Sheree, would you be willing to introduce our guest and tell us what he's about?
What my name is about usable. Good afternoon. Thank you for coming. It's going to rain, like I was saying, in about an hour, so you'll be glad you're here. Mike Wozniak is the Right to Farm Program Manager at Michigan MDARD, and I've had a couple of very educative conversations with him, and then I thought it would be selfish if I don't share them with you all. So Mike has graciously agreed to give us his Saturday afternoon to let us all know in front of his wisdom about what he knows about Right to Farm, GAMS, and the goal of this training session is to try and understand how the GAMS and Right to Farm works with local ordinances where it may preempt, where we're not sure it may or may not preempt, and just to get an understanding because we are a rural township. With that, I will let Mike take over. Thanks, Mike.
Thanks, Sheree. Do you guys need me to use the mic? Can I talk openly? No? You're like, all right. Yes, hi. My name is Mike Wozniak. She said I am the Right to Farm Program Manager for the Michigan Department of Agriculture and Rural Development. Before that, I really started in 2020 as I got demoted to manager. Before that, I was the West Michigan inspector. I live out in Muskegon, and I covered pretty much the whole west side of the state as an inspector. Before that, I'm a licensed engineer, and I was a consultant, and I designed livestock facilities, waste storage facilities, transfer facilities. I went through permitting for large operations to go through Eagle's permitting process. I went through and did site selection, as we're going to talk a little about today, designed and figured out how operations can meet that. Before that, I was a conservation technician out in Van Buren, and I went through and designed conservation practices for the USDA Natural Resource Conservation Service. And I'm a Michigan State grad, and I was telling somebody I actually grew up in Heartland, just a little north of here, so it's, if anything, it's nice to be able to come back home. Connie, be mad at me if I didn't share with you. If you ever leave me a call and hit my voicemail, you'll hear a nice long rambling list of titles. I am also the department's spill response coordinator, so if any time there's an agricultural spill in the state, it hits the phone in my pocket. I moonlight with DNR wildfire teams as a logistics section chief. So if the Grayling wildfire, that Wilderness Trail fire we had last year, that was me, that was my team. We were up there and I provided logistical support overseeing that. The last couple of weeks, I've been serving on MDARD as the incident commander for MDARD's response to high-path avian influenza as we're trying to combat the almost endemic spread of that across our state. What else do I do? I also run our aquifer dispute resolution program. So if let's say that you have a well that's gone dry at your personal property and somebody has an irrigation pivot next door and you believe that it was because of that irrigation pivot that your well went dry, that call goes to my phone as well. More than anything, what I'm telling you is thank you and continuing your support. I'd like to continue to put in for more FTEs, full-time equivalents, so I don't have to do that all by myself. But Michigan Right to Farm Act, if we go ahead and get into it here. Who's ever heard, I got right to farm, I can do whatever I want? Because I can tell you, that's not a thing. That's not what Right to Farm is. What Right to Farm is about nuisance mitigation. Nuisance. There's really two different types of nuisances. there is private nuisance, or the interference of one's personal property, or public nuisance. Interference with the enjoyment of our greater land, water, surface water, groundwater, our public areas. That would be considered public nuisance. But the Right to Farm Act is built around agricultural nuisance. It specifically goes in there and talks about odors, noise, flies. Aesthetics, as you guys very well know, is a nuisance. And the question I often get from townships is blight. Do you guys cover, that broken down tractor in the front yard? That could be considered a nuisance. And the answer to that is no. I don't have any language that describes the equipment, the storage of equipment for farm influence. The Right to Farm Act goes on to discuss certain definitions. It goes through and defines a farm. The land, plants, animals, buildings, structures, including ponds used for agricultural activities, machinery, equipment, other appurtenances used in the commercial production of farm products. Yes, the farm under the Right to Farm Act is for the commercial production. It goes on to talk about farm operation, the conditions and activities that occur that are necessary in connection with the commercial production of farm products. So what are farm products? Farm products are basically defined as food, feed, fiber, or fur, but those plants and animals that are used to human beings produced by agriculture. And then it includes a nice, long, heavy list that is not intended to be inclusive or exclusive, but rather exemplary. So a little bit on the Right to Farm Act history before we get into some more specifics. The Right to Farm Act was established back in 1981, amended as recently as 1999. It establishes the generally accepted ag management practices. These ag management practices, we'll talk a little more, are held by the Michigan Commission of Ag and Rural Development. It is their GAMS, it is their documents, it is owned by them, and it provides for criteria in which the farm can utilize an affirmative defense from being considered a nuisance in court. So, specifically out of the Act, it states that a farm or farm operation shall not be found to be a public or private nuisance if the farm or farm operation alleged to be a nuisance conforms to the generally accepted ag management practices. The law goes on to state that these are reviewed annually by the Commission, which means that they could be subject to change, sometimes massively, annually by the Commission. We'll talk more about how the GAMPs are formed and who sits on those panels. So we mentioned earlier that there's an amendment back in 1999. That amendment specifically required two things. The first of which is the establishment of the site selection GAMPs. And that included your guys' favorite, preemption language. States in there that it's the express legislative intent that this act preempt any local ordinance, regulation, resolution that purports to extend or revise any of the provisions of the act or the GAMPs under it. The way I like to simplify that when I talk to people is wherever the Act or the GAMPs provide standard or specification, that preempts any local control. We go on to state that in order for that to be, the land, the owner, the farm has to be in conformance with that language. So a determination needs to be done by the department to show that they are following that language. And we'll talk about that a bit more too. So, frequently asked question, if it preempts local statutes, where does it not preempt? We don't preempt any other state or federal law, and this comes up quite a bit. That includes state building code, as you guys, I understand recently from your own lawyers. Construction Code Act, there's a thing in there regarding agricultural building permit exemptions. That's not right to farm. We don't have any dog there. That's state building code. Animals at Large Act. This is something that comes across my desk all the time. Somebody's cow is on my property and staring it up. That's not right to farm. That's actually animals at large, and that falls under local law enforcement or local animal control, depending on how well funded your area is. Pesticide laws. We have a pesticide plant pest management division within MDARD, and they have authority there. Animal abuse and neglect. There's not enough food, there's not enough water, the shelter isn't good enough, they're up to their knees in manure. Those are all things that, again, fall under penal code, which is, again, local law enforcement. We don't have any preemption over state and transportation laws. So we get complaints about farm machinery tearing up the road. We don't have any preemption because there's another state law that already handles the maintenance and use of our roadways. Food safety, and the one that I get the most calls about is liquor licensing. So we'll talk about that a little bit in farm market camps a little bit more, but they have the right to grow it, they have the right to sell it, but we can't preempt other control. And as you guys know, under liquor license, you guys have some authority there to issue that permit. Thus, we can't preempt that. So the generally accepted ag management practices are intended to be uniform, science-based standards for all farmers across the entire state. So whether you live up in Sheboygan, Menominee, or Webster Township, that language is intended to apply to all equally. You can already see the wheel spinning how you do that. So the law requires that the commission receives input from Michigan State Ag Extension. We put on there Ag Bio Research. It requires from Farm Service Agency, which is still existent, but in an age gone by because they have since split into Natural Resource Conservation Service and Rural Development. They sit on these advisory committees. Our old friends, formerly known as DEQ, Eagle, Environment, Great Lakes and Energy, they have representatives that sit on these advisory committees. DNR, we actually have people from township associations. Michigan Township Association has lawyers sit on these advisory committees. And it actually specifically calls out industry groups. So we have folks from Farm Bureau, Michigan Environmental Council, Michigan Milk, Michigan Pork, Allied Poultry. They all will equally have representatives as well. So this is actually already outdated because earlier this summer I finally got a chance to go before the commission and formally request the adoption of a greenhouse camp. So we now, moving forward, hopefully soon, you hear my bated breath, but we will have a greenhouse camp in the coming years. The rest of them you can see for yourself on the screen, and the ones that we get the most work is really our manure management camps, the storage, the utilization, the transport, the application of manure on livestock facilities. And I know the questions you guys have the most on, site selection and odor control, or language that describes where livestock can be housed on the landscape, and the management that they are required to implement for conformance to mitigate nuisance conditions. I'm going to keep saying nuisance as we get through this because the whole point of Right to Farm is management practices to mitigate nuisance. The GAMPs identify this management that, based on science, is intended to mitigate nuisance conditions. So the law goes on to provide MDARD with authority to do two things. First, and we'll talk about this a little bit more shortly, facilitate the annual GAMPS review process. As we stated back in there, the commission is required to review that annually. So we help facilitate, which basically means we'll set up meetings and take public comment. I'll talk about that a little bit more in a minute. But the other part is to determine whether a farm operation is conforming to the GAMPS. In fact, the language directly out of the law, the director shall investigate all complaints involving a farm or farm operation, including but not limited to complaints involving the use of manure and other nutrients, ag waste, dust, noise, odor, fumes, airs, pollutants, surface water, groundwater, food, agricultural processing byproduct, care of farm animals, and pest infestations. So basically, it is upon the department to determine conformance to the generally accepted ag management practices. The law provides MDARD with the authority to investigate for conformance. Now we do this basically in two ways. One, at the request of the farm. We call that a proactive review or conformance review, where the farm says, hey, I'd like you to come out and investigate us for conformance with X. Am I allowed to have my backyard chickens? Or am I allowed to have a farm stand? They're complaining about my manure storage. Can you guys come out and see if I'm following the language in that applicable GAMP so that I may utilize the right to the Act's protections and preemptions? The second is in the response to the complaint. Anybody can file a complaint. In fact, my biggest client is our Eagle, Environment, Great Lakes, and Energy, and that's because of a memorandum of understanding that unless it's an NREPA, National Resource Environmental Protection Act, violation, all other agricultural nuisance complaints is first attacked by my team, or investigated by my team. So how are changes made at the GAMS? Well, the law specifically states that the GAMS are owned by the commission. It is the commission's documents, not mine, not the department's. It's owned by the commission. So they can change it at a whim. In fact, that happened to me, I think it was 2018. I was in court with a farm that had livestock, and there's two different definitions in there between livestock production facility and livestock facility, and we specifically had the word pasture in production facility. Well, this farm only had a couple hogs. It didn't qualify as a production facility, but we didn't have the word pasture in livestock facility. Now, that's never how we interpreted it. We've always gone out and understood pastures to not be part of a facility. Well, the judge said that was intentional. And it wasn't intentional, it was an oversight. Well, the commission, as soon as they caught wind of it, the next meeting changed it right there on the spot. They added the language directly to the GAM. They can do that. It's their document. The law gives them the authority to do that. However, it also states that they shall take due recommendations from the department. We provide feedback. This is what we're seeing in the field. This is how this is being interpreted. Is that what you intended? Or we're having issues with this. This is what's said. This is what's happening. And so they may change due to recommendations. The intent of the GAMS advisory committees is to also implement language changes, new technology or research is identified. These advisory committees are led by a chair, typically, almost all of them, one of them is retired, from our Michigan State employees, either directly from the university or extension service. And then they form the advisory committee. This is all you can find through the commission's policy manual. And I think I'll talk about that one on the next slide. So they make up the advisory committees. MDARD does not chair the advisory committees. It is a third party that goes through and does that. And they're made up of the people that we talked about before. And then probably the largest driver of change is through public comment. You'll see here up on the screen is a timeline. This is basically the timeline that these advisory committees are given to work. With the formal adoption in November for printing and posting at the end of the year, they work on it really through July. And then I need that document by mid-July, so I have several late nights going through it, me, myself, and I, going through and making sure that the formatting looks good, there isn't any spelling errors, we have it cleaned up under red underlined text so you can clearly see what the changes are, and we do that for all 8 sets of documents. And then we post that at the beginning of August, draft comments for public review. And then that's finalized at the end of August for the hearing, where I get to sit with a room, usually with a bunch of people like yourself, and they get to come up and provide comment. We say, thank you for your comment. That comment is then collected and then presented to the executive office, the Right to Farm program, the advisory committees, and the commission. Every single public comment, regardless of its validity, is reviewed and handled in this manner. So we talked a little about the annual review. As I stated in there, it's reviewed by the advisory committee. They're chaired by the dean, chaired by a person appointed by the dean of the College of Ag and Natural Resources. I can tell you that I was heartbroken to hear that Dr. Kelly Millenbaugh had just retired, because she has been a tremendous asset. And then that dean goes through and appoints individuals, as we stated in the previous slide, to make up that advisory committee. They may also appoint other individuals as necessary as subject matter experts for maybe a particular question or issue that we're trying to handle. That's something that I'm going through right now, Dr. Eric Runkle, for building a greenhouse camp. We're going through and identifying what are the nuisance conditions that we want to identify farm management practices for that would mitigate those nuisance conditions. And then who's the subject matter experts from within that world that the law identifies to be able to identify how to fix them. These advisory committees' membership is also reviewed annually. Once we tackle a problem and that subject matter expertise may no longer be needed, we might identify somebody new, or they retire or ask to step down. So we talked about that really we go out and we have two responsibilities, facilitating the annual review and complaint response. Apparently I have a slide here that disappeared. When we go out and complaint response, we're going to identify with the farm that we received a complaint, that the law requires we're out there within 7 business days, and so that they can choose to accept or deny our investigation actually, because again, this is voluntary. They can choose to go through their life and not be found in conformance. Because again, with it being an affirmative defense, they can choose to try to go into court without right to farm. That typically doesn't happen. You know, we're free. But that can happen. They can choose to go through and do that. So we identify within that we received a complaint. We're out there within 7 business days, and the law requires that upon receiving the complaint that we send a letter to the farm identifying that we received a complaint, to the township it resides in, and the county. So that we do that. And then we follow up with the complainant once we've received the complainant been on site and identify kind of what we've seen. Now let's say there's an issue. Let's say we get out there and the farm is in fact found not to be utilizing the generally accepted ag management practices with whatever the details of the complaint is. We'll go through and identify with them and how that does not meet the language in the GANs. We don't quite have the authority, though, to direct them to resolution. Hey, you need to build a new manure pit. It's falling out of order. Now we can go, what we typically do, though, is identify, here's the standards that your storage needs to meet by. Here's the standards for having a farm market. Here's the setbacks that it's required to be. It's usually not too hard to figure out, oh, I need to move it 15 feet. Yeah. But really, we try to mitigate nuisance. The law states that if we find it's an issue, that we give them 30 days to either fix it or submit a plan. And that plan has to be, we call it a schedule of implementation. What they're going to do and when they're going to have it done by. And we have to follow that plan. We try to partner them up with resources. Depending on what the issue is, we'll go through and identify resources out there in the field that we have relationships with. Conservation districts is a big one, because they're free. And they have technical advisors there within their office that often specialize in crop management, manure application, nutrient, pesticide management. And some of those individuals include the meat technicians and a partner program of ours. We'll often direct them to try to work with them. USDA Natural Resource Service is supposed to provide technical assistance in helping design and identify and mitigate issues that might be of public nuisance, groundwater, surface water concerns. And sometimes it's as simple as asking for funding. One of the issues that we come across quite often is cattle in the creek. Well, as you may be aware, NRCS provides fencing. So we'll often, if they got a long mile of fencing they need to install to keep cattle out of the creek, we'll often identify with them, reach out to your local Natural Resource Conservation Service, talk to your conservation technician there, and go through the process of working out a plan and have them pay you to try to help put a fence in. Because our goal here is to mitigate the nuisance. Get them to get the cattle out of the creek, no longer cause water quality degradation. But ultimately our goal is to pragmatically and quickly resolve nuisance issues. So the other aspect that we said, the other review that we do is those proactive reviews, conformance requests. This really comes down to 2 different types. We have our small farm, and that's our typical proactive review, and we have our larger production facilities. That requires them going through a whole site selection process. The reason why this is so different, and we'll get into it a little bit more with siting, but with siting we're really only looking whether or not they're primarily residential, if they're a small, under 50 animal unit facility. If they're over 50 animal units, well, that's a lot more intensive process. We're looking at a lot of different setback requirements, public requirements as far as they have to be 1,500 feet from grocery stores, graveyards, churches, township halls. Is there an odor? If they have to identify an odor plume. And we have to go through and look at that 95% odor annoyance-free interval and identify if there's any neighbors within it. How many neighbors are within a quarter mile or half mile? So as you can see, it is quite a different process. When we go through and do this, we have to get it in writing. The request has to come in some sort of documented form. There's no mandatory timeline with the proactive review. When we receive a complaint, the law requires I'm out there within 7 business days. When we receive a proactive review, it's at the producer's request. So we're not getting out there immediately. In fact, the impetus is they don't have conformance. So until we get all the information we need or changes are made, they don't get a letter of conformance. And so we're at their discretion as far as how far they go. Farm market GAMS. We'll get into some of the specific GAMS. I'm going to cover farm market, manure, and siting a little bit, because those are the ones that are of usually most importance and get the most attention. The farm market GAMS identifies where the physical transactions can occur, the actual selling of farm products. And it protects the selling of farm products that you produce. It doesn't protect the selling of Michigan State paraphernalia, wind chimes, things that are not farm products. That doesn't mean they can't sell them, they just can't go through and sell them under right to farm. Because right to farm is about the commercial production of farm products, products that you produce. So it goes through and describes that more than 50% of the total farm products that you sold have to come from your operation. They must be at least 165 feet away from any neighboring home. It can't be placed on what we call platted lots. The language directly in the GAMS is described as platted lots, but that's basically your subdivisions. Stony Creek Estates, that's a platted lot. Can't be within those. It describes parking, signage, lighting, some other things, but mostly what it states in there that they're allowed to have it, but they have to follow local ordinance in order to do it. That's actually came up recently. We had an operation up in Interlochen that the area was zoned, I don't even remember, I want to say residential something, R3. And it said in that zoning that they weren't allowed to have signs at all, period. Well, the GAMS says they can have a sign. So that actually ended up going to court. And the judge required them to allow them to have a sign, but they had to follow the ordinance for other residential zones in terms of setbacks from the road, height requirements, lighting requirements, because we don't have any language in that. I don't want to put any language in that, because that doesn't make any sense, as I said before. The language that we have in the GAMS has to apply from Schoolcraft to Benton Harbor to Monroe. So it doesn't make a whole lot of sense that I'm putting in height, setback, lighting requirements when Webster Township is going to be a lot different than downtown Brighton. You don't want the same, you don't want it to apply to both. So we don't want to go through. In fact, whenever we're going through and introducing language, that's something that we routinely talk about. What is the implications of this across our state, across all the different communities that language will end up applying to? So the Right to Farm Act protects your ability, as I said earlier, to produce and sell. It doesn't protect processing. So you can grow blueberries, you can sell blueberry pie that was made with your blueberries, but it doesn't protect you making the blueberry pie. That's considered a processing activity. Same thing with wine and cider. You have grapes. If you meet liquor control, you can sell the wine, but the making of the wine is not going to be protected under the Right to Farm Act. Obviously, building permits as well. We talked about that a little bit earlier. So the manure management GAMS is about the production, the transfer, the collection, any treatment, I didn't mention storage, and then utilization. So basically, from when it comes out of the animal's backside, where it goes across the entire stream, and then how it finally ends up out in the field. Because manure is supposed to be utilized as nutrients for crop production. And that must be done at agronomic rates. So the manure management GAMS is going to talk about you have to have a soil test. What's your baseline nutrients? Your crop plan, what are you growing? What is the average yield you get out of that? And what is the nutrients required to get there? And then you apply that nutrient source and manure at a rate that meets the crop's needs. You have to identify and have certain setbacks from surface water, from sensitive areas. Now, some of those numbers aren't really hard and fast because the setback on a flat field in Huron County is going to be a lot different than a 12% slope in, Clinton County. You're going to need a lot bigger setback. It's going to require certain conservation practices, cover crop, no-till, buffer zones. The requirements for something that is conservationally tilled corn is going to be a lot different than hay. So the language in there is not going to always specifically say you have to be 100 feet, but it's going to require that it doesn't leave the property and it doesn't negatively impact. A large portion of manure management GAMS is going to be talking about odor management. Not just the application, but odor coming from the farm itself. And that's from your outdoor lots, from runoff control, from your manure storages, for example, and everything in between. How are you managing that odor? This actually works kind of closely with site selection GAMS because as you get larger, that's a large part of that odor model. So if you're storing the manure, let's say in a stockpile, they gather manure out of the barn, mix it with their hay or bedding, and they decide to let it stockpile up on the side on the farmstead. They can do that uncovered for up to 6 months, a year if covered. They can never use the same location if it isn't impervious for at least another 3 years. And then in between, it requires to be utilized in crop production, trying to mitigate the nuisance of nutrient runoff, nutrient leaching. The site selection GAMS, everybody's favorite, identifies the placement of where livestock can reside on the landscape. The site selection GAMS is going to be based on what we call animal units. An animal unit is 1,000 pounds of live animal weight. Everything under 50 animal units, yes, 50,000 pounds of live animal weight, is going to be considered a small operation. We'll get into that more at the next slide. Everything over 50 animal units is what we call our production facilities, our large livestock facilities. Once you reach to that, then we're going to start looking at different setbacks from property lines. Starts at 250 feet, goes all the way up to 600, depending on the number of animal units. We're going to be looking at an odor management plan. Now, granted, odor management plans are really something a part of almost every livestock operation because of its manure, but an odor management plan from the facilities itself. That's when we talked earlier about an odor plume. And, really the other part of that with odor management that we got to think about, that we're thinking a lot more about, is mortality management as well. And you're seeing new language in the GAMS this last year, largely in response to the last couple of years that we've had.
I'm sorry, mortality?
Mortality, correct.
Of?
Livestock. Thank you. All right, so primarily residential, your backyard chickens, your small operations. The site selection GAMS state that if you're category 3, if you're not primarily residential, you may have livestock if you're under 50 animal units. Category 4 in there states that you may not have livestock of any number if it is in fact primarily residential. So what is primarily residential? It's the definition in the site selection GAMS states that you cannot have any neighboring residents within 250 feet of the livestock facility, the barn, coop, an outdoor lot, where it's not dominated by desirable forage or the density is such that you have to manage the manure and runoff. Notice it doesn't include pastures. Pastures is the opposite of that, where you have a density of desirable forage, or is populated by desirable forage, and the density is low enough to not cause degradation, where it doesn't wear it down to dirt, mud, manure that could run off from the location. Those are considered livestock facilities. those are required to be 250 feet from your neighbor's home. And we're talking about the actual residence, the structure itself, not the property line. And that's intentional because if you live on a 20-acre property, or the neighbor lives on a 20-acre property, and he might be nowhere near it. But that's a lot different from somebody that lives on a quarter-acre property. The other aspect to be primarily residential is if you have more than 13 homes within 1/8 of a mile, that's 660 feet. If you meet either one of these conditions, you are considered primarily residential. And that means that you cannot have livestock under the site selection GAMS, under right to farm. Does not mean you can't have livestock. It just means you can't claim right to farm to have it. And that's where your guys' local ordinance would come in. So if your local ordinance states that you may have livestock under what conditions that the township wants, you could still have them under that condition if they're primarily residential under site selection GAMS. If they're not primarily residential under site selection GAMS, meaning they're category 3 or allowed to have that livestock, then it would possibly preempt local ordinance language, regardless of what it may say, even if it's less restrictive. And that is just the nature of that preemption language there within the Act. So this is unfortunately a little outdated because I need to spend the time to go through Power BI and list all those titles earlier to get that updated. But this last year we had over 200 complaints across the state. And we had over 110 proactive requests. My team consists of myself, as you guys are aware of, Jay Corson, who covers this area, and then we have Kyle McCarty up in the Thumb, Erica Rogers in the west, and Steve Mahoney up in the northeast. That's my entire team. That's everybody that covers the Right to Farm program and responds to complaints and proactives and does presentations like this. Complaints typically occur wherever you have the intersection of rural agriculture and people. It doesn't surprise me at all that I'm standing here in beautiful Webster Township today. I enjoy driving through and seeing the fields and the countryside. I also recognize where you guys are located. You are at the intersection of the outskirts of urban and rural and that interaction. And you see that across our entire state. You know, Oakland, Genesee County there is a pretty hot spot. We get a lot of complaints. Our outskirts of northwest Grand Rapids and my hometown area of Muskegon, Ottawa, Allegan County receives quite a heavy workload. And the other one you see up there is our greater Traverse City region, area that is quite rural, dominated by a lot of vineyards, a lot of cherries, and a lot of people from Illinois with money. So everything that I got with you here, and I guess here we'll get to questions in a minute. This is our webpage. That first tile there, Right to Farm program, there you can get the Act, which I do have a copy because I'm anticipating a question or two that I'll want to read directly from it. Complaints, how to file a complaint, and conformance reviews. The next tile there is the GAMS. That's where you can get a copy of each one of the GAMS that's current. We also have archived GAMS up there now, so you don't have to submit a FOIA for it because that's public knowledge. Why would we not have it available? So that's up there now, as well as additional resources for answering any other questions we talked earlier, like construction code, biosolids, the GAPs, the generally accepted processing practices that discusses nuisance from noise and odors from processing facilities, and all the litany of other information. And then that last slide, that tile that I left out, is site selection. Part of the site selection process is that you receive what's called a site suitability. That opens a 30-day window where anybody within a half mile that owns land within a half mile, or any township or county within a half mile of the proposed facility, may file an appeal. So we actually have a list of producers within the last year who have gone through and received site suitability, a little hot link to some imagery of their operation, some details regarding the operation, and then some dates. And I bring that up last because that usually brings the, wait, what? How does this work? That's that. And of course, that's all available. You can look at any time. I grabbed diapers and jumper bags instead of business cards, so that is my cell phone, that is my email. Please write it down on the street. I can tell you I'm always happy and available to answer any questions that you have. I guess at that point, I can get back to you guys for questions.
You gonna call out people?
Go ahead.
Alright, so I got a couple. When we talk about, it doesn't preempt any state or federal statutes, does that include the drain code?
Yeah,
Because, I mean, they're county drain commissioners, but it's the Michigan drain code that they enforce.
that would be correct.
Okay. Because that, and when you start talking about livestock down in waterways, it's draining, they have
Yeah.
very specific laws with regards to that.
So there, that actually comes under the riparian doctrine, and that's referenced in the manure management camp. And the language really stinks, because it basically states that it cannot cause water quality degradation.
Yeah.
They're allowed to have access to it, but it can't cause water quality degradation. Which basically, when we go through and do that, do you have any sort of protected crossing? Do you have some sort of structure in place that allows them to have access to the water, but not wallow in it and tear it up? NRCS actually has funding, and that's one of the ways that we mentioned earlier, pointing to your other local partners and resources, that'll pay for a stream crossing, where they'll actually go through and put in fencing, put down rock barrier, so that they can come up and have access to the water, but not turn it into a mud. Great question.
Next one was that when you go and you do a site review and you go through the management plan and all that other stuff, and you write somebody a letter that they've met all the criteria, what's the follow-up on that? Do you guys do yearly follow-up? Do you do any follow-up unless there's a complaint? I mean, once somebody gets a letter, is it good for there on out, or what is the time frame on it?
Absolutely, great question. No, as we say, my resources, we have 5 people in the program. I think over the history of the program, at least as far back as our database goes, we have over 8,000 complaints that we investigate. Furthermore, the law only requires that we go out and investigate a complaint within 7 business days. So not only do we not have the resources, I don't have the authority to do any sort of follow-up with them. It's a complaint-driven process. Now, just because they've gone through and received a letter, that doesn't mean that they're protected for perpetuity. Of course, if you change your management, that's no longer going to be valid. Or if you lied in the information that you provided, that's not going to be valid. So it's tough. It is a tough one, because I get that quite a bit, where it's like, oh, am I good? Like, well, did you change anything? Has the conditions changed?
A follow-up to the site plan. When you're doing a site plan and you talk about distance between the residence and the site, how do you determine what's a home or a household? Especially nowadays, where you have people turning what would have been a factory or a barn or a garage into a home, and that may possibly be split off. How do you recognize that that's a house or not? Do you look at adjacent property, basically their lot plans, or do you just kind of look around and see what you can see? How do you determine that? Because there's good room for error there.
Absolutely, and it's something that we're constantly evaluating and trying to figure out how do we best utilize our resources, but how do we get the absolute best information. Quite often, we require the person requesting the review, the police supply names, addresses, locations of your neighbors. And then we will, counties like Washington, where you guys have an awesome county GIS portal, we'll go on there and identify that, because it's usually pretty accurate in terms of who's there, what's there, if it's a residence. The ones that always give me heartburn is if it's owned by trust, because then you really just don't know until the third and final step is we do a drive around. We'll actually go out and identify, is this a habitable structure, or is it a falling apart hunting shack? It's obviously not a residence.
Is an apartment complex one residence, or every apartment's a residence?
Yeah, we consider each individual unit.
Sorry, folks, I got 2 more.
Finish up.
Once somebody gets a letter, how do they lose it? You said in perpetuity. I mean,
No, I said it does not reside for perpetuity.
oh, right, that's what I mean.
All right.
So is it you guys coming back out and saying they no longer meet it? or, and this follows up with another thing, is there a list of GAMP farms that you guys keep that you would add or take people off of to show basically that somebody is GAMP certified or not?
Actually, your folks, you would answer that. Basically, what we ask you is file requests. If you have an operation that you are concerned about, or that they misapplied information to us when we were out there, tell you file a complaint. In light of this, then we'll go out and review with that, considering that information. Because that'll happen, where they'll oh no, these ducks aren't mine. Then we go, no, they've been there for 2+ years. We'll go out and ask them, please, provide accurate information.
And do you have a list? Or no? No list?
And realistically, as we stated, like, as an operation changes, any determination that would have been done may no longer be valid. As markets ebb and flow.
Right. Sorry, I got one more.
Keep going.
If, what happens if, and it's really not fair to the farmer or the property owner if this happens, but what happens if somebody buys a lot next door and they've got their farm all set up and that used to be a field and now all of a sudden somebody builds within 250 feet of them?
Michigan Right to Farm Act 286-473, Section 2, or 3, number 2. A farm or farm operation shall not be found a public-private nuisance if the farm or farm operation existed before a change in land use or occupancy within 1 mile of the boundaries of the farmland. Absolutely. The law addresses that itself. The part about that you didn't get to that isn't fair. The farm can't expand. So now if they wanted to bring in more animals, they have to go through site. I mean, if that house built right there, within 250 feet, or within whatever setbacks may be, if they're within the odor plume, they have to sign off on it. If it's just within 250 feet, it's sorry. You can't.
So it's in the property owner that has the camps, it's in their best interest if they add property or add animals to contact you guys to change the site plan. So therefore, if somebody moved in and built next door, then that would be recorded.
I got language here on that too. No, instead of waiting up for time for me to read directly, basically, when they go through a siting application, they're expected to identify any expanded holding capacity within 3 years. So if they're going through and, let's say, submit an application today, I'm going to ask them politely, is this everything you're planning to do within the next 3 years? Because if you go through and do it again, the language in there no longer considers that expanding. That's now a new facility. And that's going to require larger setbacks, less people.
Mr. Webster. A claim under right to farm requires a commercial component. How do you demonstrate a commercial component? Who makes that determination? In other words, if I sell a dozen eggs a week, is that commercial? I don't think so. I think that's a recreational activity. I think that there should be something more. So the question is, number one, what constitutes commercial, and number two, who makes that determination?
So, sure. I apologize. All right, so 2 ways I'm going to answer this. There's my official answer, then my opinion. The official answer is MDARD does not determine if you're a commercial operation. We do not have the authority to do that. We only have the authority, again, to investigate nuisance complaints, determine conformance to the GAMS, and then facilitate the annual review. So we don't, so my opinion, so we don't determine if it's a commercial operation. And there's the rather famous court case, 2005, Township of Shelby versus Papish, if I may oversimplify through summarization, basically said whether you sell 1 egg a year or 1 million eggs a day, you may be commercial by nature. The way I typically get, when I get this question and I talk to producers and townships, because I get this question a lot, is there's a big difference between having a napkin agreement with your neighbor across the street that I buy a dozen eggs from you every week, and somebody that utilizes QuickBooks. Because ultimately, to the other part of your question, it's up to a judge. You have to prove to a judge that you are in fact commercial by nature. And I've had a lot of talk with one of your coworkers here about this, because your guys' authority resides under the Zoning Enabling Act, which doesn't give you the authority to determine conformance to other state laws. And I don't have the authority to determine if it's a commercial operation. So then it has to fall upon a judge, because what they're trying to do is utilize right to farm as an affirmative defense. So they have to show that they're in conformance with the GAMS, a farm operation, and the commercial production of farm products. They have to prove that to a judge. If you meet those things, then the judge will hopefully award right to farm protection from the nuisance litigation. So and ultimately, in a long-winded way, I can't do it. I don't think you can do it. I think it's got to fall upon a judge.
Mr. Kingsley? May I ask a question? In the same vein, so I grow hay, I sell hay, I make money. Does that give me the right to have pigs?
Yeah, I get this sort of question all the time, and I struggle with it myself because in the law, 286-473, section 3, number 3, if a farm or farm operation is in conformance with subject shall not become a private nuisance if the result of any of the following: a temporary cessation or interruption of farming, and that's B, and then C, or excuse me, E, a change in the type of farm product being produced. So I don't have a great answer there because I don't understand what I just read. Because there's the site selection GAMS, which describes where on the landscape you can have livestock. And if you're bringing in pigs or you're previously a hay operation, that's a new livestock facility. So as I understand it, you need to go through site. You need to submit a site selection review and determine if you're in conformance, because that's a change. The land use of the people around you might have pre-existed, but you didn't have pigs on there, and now you do.
May I ask
A
another
quick
question?
follow-up on that. If you have pigs and you meet the site selection or whatever needs to be done, and can I have sheep?
Yeah, that's a great question. We look at it in terms of holding capacity. So this actually came up before a judge, a lawyer was grilling me over and over and over again. Did MDARD go out there and determine holding capacity? To which I just kept politely responding to him, holding capacity is dependent on management. I can have a 10-acre field. Let's say it's pasture. The quality of that pasture is going to determine how many sheep you can have on it. Well, let's say they now bring in additional bales. You can hold more sheep. Now let's say instead he decides to build a barn. You can hold a lot more sheep. Well, let's say that barn now has layers. It's a lot more sheep. You're not talking tens, you're talking thousands. So we determine based on holding capacity, and holding capacity is based on management. So to answer your question, does the determination of hogs allow you to have sheep? I'm going to tell you it depends on what the management practices were in order to have the hogs. And how are you bringing sheep on? Are you removing hogs? Or are you building a whole other wing or additional management practices to bring those on? Because that would be expanding your holding capacity and thus require siting. And manure plan and everything else, that's correct.
John? So I've heard frequently, right to farm act is a shield, not a sword. Do you agree with that statement?
That was absolutely a Supreme Court case. I think it was Scholzman versus Ottawa County. Correct.
Thank you.
I don't grow hay, I don't have hogs or sheep, but I'm curious about manure.
All right. I heard it's free money.
So early on, you indicated that if there's manure and the animal's up to their knees, it falls under the animal abuse and neglect penal code for enforcement of it. item within the GAMP list of items. So how do those two really shake out?
Great question, and thank you, Nick. I apologize, that was a poor example, because you're right. What my counter question is what's the concern? Is the concern the manure management, or is it concern animal welfare? Because if the concern is animal welfare, there's some tie over under the care of farm animals camps, and I'm not a veterinarian, but we have an animal industry division that's full of veterinarians, where I would bring a veterinarian on site to try to help me assess the animal's care and health and quality of living. And then if there's an issue with the animal's care and quality of health, under Animal Industry Act, we're required to refer that to local animal control. Now, if the concern, I apologize, is manure management, then we would go through and assess how that manure is being managed, and is it allowed to run off? Is there degradation issues? Are you storing it? Are you allowing this to build up there in the field for a year? That's not necessarily acceptable either. So
the the GAMP doesn't necessarily relate specifically to animal care, even though I would imagine good management practice would separate in some manner a pile versus where animals are living, at least in an overnight situation.
I think I would state that the GAMP doesn't drive the investigation. The complaint drives the investigation. We investigate the details of the complaint as they pertain to the generally accepted ag management practices. So if the complaint is manure management, I'm not going to go up to the front of the driveway and look at the farm market. We have a farm market GAMP, but that wasn't what the complaint was. So you have a very fair point, but we don't, the GAMP doesn't drive where it goes, the complaint does.
Okay, and then just a couple quick questions. In terms of when there's a complaint filed and an issue needs to be addressed, what's the percentage of people that fix it immediately versus put together a plan to address whatever that item is? John.
Yeah, I would say about half of the complaints that we receive are verified. And then of those verified complaints, about half of them require some sort of schedule of implementation. That they don't just fix it within 30 days. And about half of those end up being referred over to Eagle for non-conformance and potential investigation for violation under their protocol if they so choose.
Okay, that's good. I appreciate that there's that follow-up in terms of sending off to another agency or any agency.
Well, and regardless of the outcome, as township, you are notified. We send a letter to every county and township of the result that we received a complaint, that follow-up investigation is being done, because you'll see in the app, it actually requires that we inform you that we're doing an investigation and allow you to join us, though that's never happened. I've never had a township say, I want to come. and then upon closure. So you'll, as a township, you'll receive notification that this file is closed and this is the outcome.
Okay, great. And then finally, the two different types of reviews, small versus expanding, what's the split on that in terms of what you've been most work in?
I don't understand the question.
Farms, small farms, less than 50.
The under 50, over 50? Oh, well, this last year we received, I think it was 12 site selection reviews, so the over 50 animal units, the large ones. Well, as I said earlier, we received over 115 proactive reviews. Though the number of those that were backyard chickens and the number of them were farm markets, I couldn't tell you. I'd have to go through and actually break it out. And that's not a report that we typically do, but now that you suggested it, I might have to start doing it.
Generally curious. All right.
No, thank you.
Thank you.
Just based on the questions you're getting and the follow-up questions you're asking us, it seems to me like the interpretation of the right to farm law really is very specific to the situation oftentimes, right? It's not a general, it's written generally, which is how a law is written, but how it's actually implemented is pretty complicated in terms, right? Like a lot of them are going to end up, if the township or whoever disagrees, it's really up to the court to make that final decision, am I right? Is
Yeah.
that assumption?
Yeah, absolutely, and thank you for justifying my job.
Right, okay, so and what I'm getting at is that it doesn't make sense, unless I'm misunderstanding it, for us as a township to reference right to farm even in our ordinance, because we can't enforce that, we can't interpret one way or the other, it's really up to experts to interpret that. And so we really should be writing our ordinance in the way that we want to see people behave, whether they're right to farm or not. And then if they are right to farm, then they can come forward and not follow the ordinance because they already have the right to not follow it.
With determination.
With determination, right,
It isn't
exactly.
just automatically granted. There's a lot there to unpack. I guess the thing I would generally say is that the GAMs are reviewed annually, and so they're subject to change. And I know the process of having an ordinance reviewed and adopted is equally painful. So going through and adding specific language from a specific GAMP, I think is very dangerous to do, because they're always subject to change. And I, second the other part.
You started the presentation by stating that the whole purpose is to mitigate nuisances. So how do you measure these nuisances? If I can smell the pig farm, that's a nuisance to me if I want to have a barbecue out in my backyard. But obviously, the pig pen is going to smell. So, is that you go out there and I can smell a pig farm, but it smells like every other pig farm, so it works for me. There's nothing here that I find unusual, and that's not going to be very helpful to the neighbor who can't go out and enjoy his backyard barbecue. So I think nuisances are in the very discretionary at best.
Absolutely, you nailed it. And historically, before I came on and before I got demoted to manager, the program used to have people drive around with the window down and be like, can you smell it? Here's the problem with that, as you already identified. It's extremely subjective. One person thinks it smells horrible and another person may not be able to smell it at all. So what do? So the way we do it is, what is their management practices? The GAMP specifically identify what things they're supposed to be doing to be mitigating that nuisance control. So you're talking about a hog operation. Are they wallowing in wet manure? Because if that's happening, are they preventing it from leaving the site? Is there some sort of controls being put into place to try to help mitigate those concerns without going through all those specifics? So the manner in which we go through it is objectively. What are they doing? What is their plan? What does the language says? And then we ask them to, if it's an issue, to adopt as the language describes. Because there's language all across the siting GAMPs and the manure management GAMPs that would contribute to farmstead odors.
So, just to follow up, and the fact that it smells is not the issue. The issue is, is the farm following the recommended practices to mitigate the nuisance? That's what.
Basically, yeah. Because odors are, again, subjective. If you can smell it and I can't, what do I do about that? So.
And this is unrelated, but it is an issue that came up here in this township years ago. An operation that was claiming the ability to have a roadside stand under right to farm. That operation imported basically plants to sell in pipes. And so these obviously were not produced on site. But the argument was, okay, I brought them on site, I now buried them in mulch, I water them every day, and the argument was that they now 50% requirement. And I saw absolutely no logic to this, but I would be interested in your comment on that.
This is actually something that came across our desk in the last couple of years as well, for operation relatively close to you guys. And we spent a lot of time investigating exactly that. Where's the differentiation between bringing them in and immediately selling it and being a nursery or grower, which is a value added? And the language that we ultimately got from is from our counterparts, and that, I don't have it directly in front of me, but so if I may simplify through summarization, whether you are up potting, so going from a 6-inch to a 10-inch pot, if you're overwintering, so you bring it in the fall and then you sell it the following spring, some of those practices would then constitute as a grower or a nursery, and then would be considered your product. Now, if you just brought it on in a hanging plant from somebody else and turning around and selling it, yeah, it's a farm product, but it's not your farm product. And then they would have to provide the documentation that they're doing these things. On top of that, I don't know what the thresholds are, but there is a licensing requirement for nurseries and growers.
Thank you.
You're welcome.
You mentioned 50% earlier about sales that needed to come from the farm. By what? By weight? By dollar?
Yeah, and this language is often problematic because it's or, so they can choose. It's 50% of products sold from peak sales or by square footage. So they can either identify this is their square footage, and unfortunately, that could constitute acreage. But I have to look up exactly what the language in there is in the farm market camps. But it is by gross sales during peak season or 50% by square footage of that area of those farm products that you are producing and selling. You're welcome.
I noticed earlier on that there doesn't seem to be any penalty other than revocation of basically your letter signifying that it is an approved farm operation. If somebody lies to you when they're producing the materials for the inspection, there's no penalty as such.
So if I may ask you if I understand what you're saying, are there consequences to false representation with an MDARD investigation? Well, I would hope that would come out in court, because the whole point of this is an affirmative defense against nuisance litigation. So if it came out in court that they're lying and producing that, then it would nullify the determination that they're in conformance to the camps. If my understanding, of course, that's up to a judge, but I believe that would be the consequence.
But from MDARD, there is none.
I have not encountered that scenario to give you a fair response. We've never, I mean, if it came forward that something was falsified, it would usually come forward in a complaint, and then we would do a new investigation. But nobody's just saying, I lied, you know, so.
As a follow-up to that though, if you did, revoke the letter, then that would mean the farm was no longer protected under right to farm necessarily, and they would come under the consequences of what the ordinance said, right? I mean, then we could enforce our ordinance, assuming they weren't following it in some way, and that was part of the complaint.
If the details of the concern are addressed within the GAMS, and they are not in conformance with the GAMS, then the right to farm's preemptions would not occur. Okay.
So, Mike, there's a little bit of disparity between when, on number 4 here, it's not really fair what I'm saying, number 4. It's on 286.74 for investigations. And this is, I think, kind of what John was getting to. So you have a complainant who brings more than 3 unverified complaints against the same farm or farm operations within 3 years, may be ordered by the director to pay the department the full cost of investigations of any 4th or subsequent unverified complaint. Shouldn't that also be true for the farms? That if they continue to have violations under GAMS, even if they fix them, that, I mean, say at the 4th complaint, and I'm not saying that you fix it, but if that's not true the other way around, they can perpetually not follow the GAMS, fix it when there's a complaint done and there's no repercussions, whereas somebody complaining runs the risk of actually getting costs.
So there's 2 parts of that. First, you're correct, the law does not identify that. But I can tell you in practice that if we receive repeat concerns from an operation and it keeps coming back year after year, they're not going to end in conformance. That's going to end up getting referred over to Eagle for violation and eventual escalation through there. In fact, there's a rather famous one that you may have not heard the Attorney General's office just filed against this last year.
Yeah, and I know that sometimes there's complaints that no matter what, they're going to call a complaint even if there's not.
Yep, we get several of those that they see the truck, they're calling.
On the reverse, they try to use you guys as the sword as opposed to.
Absolutely.
Hi. So I had a whole series of questions related to the concept that if someone has less than 50 animals, what's required of them? Because there's all these, I think it says that livestock facilities in category 1, 2, or 3 with less than 50 animal units are not required to go through site review or verification or to conform with the GAMS. And so I'm wondering if there's someone with less than 50 animals, it sounds to me like they can do whatever they want and there are absolutely no requirements. And so can you walk through what they should do and what protections they do or do not have if they do those things?
Absolutely. So I guess the first part is understanding that none of this is required. A 7,000 cow operation is not required to go through siting. It's not required to meet those setbacks. This is non-regulatory. So by not going through it for an even under 50 animal unit operation, they risk having a nuisance lawsuit filed against them or the township and you guys saying, hey man, you can't have chickens here. By not going through it, they risk not having the preemptions and protections. So that language that's in there, that's a sub note under a table, if I remember correctly, is in there as leftover language from a bygone age that really needs to be updated and removed. Several years ago, as you guys might have remembered, there was the big push to revitalize Detroit by allowing urban farms. Before that push, the language for under 50 animal units didn't even exist. None of that was in there. In fact, even our categories were smaller. And we didn't have a whole lot of the language that we have in there now. So because of that, because the GAMS are reviewed annually, and there was the big push to allow for urban farming in Detroit, of course that made it to the department, and that made it to the commission, and so the charge came to turn to try to introduce more language that allowed for small commercial operations. And that's really where you saw back in 2014, where there was language introduced to allow for under 50 animal unit operations, as long as they're not primarily residential, is the language that was added, and not to get, the other aspect is that they removed zoning. Historically, zoning was also inciting that it stated in there they had to have ag use by right, which means the ordinance allowed for agriculture. So primarily residential included language that stated and did not have ag use by right. All right, so now we're getting into the political world of it. The next part, so then we had a couple townships actually on the other side of the state that said, oh, we could completely eliminate the ability to have livestock in our township. So they removed livestock from their entire township. Nope, can't have it. Well, that may, of course, made it to the commission, and the commission turned around and said, no, that's not the intent. The intent of this was to allow for local input so that where there's areas where it was inappropriate to have. Then the advisory committee then, and this is, I had just came on this back, as I said, like 2017, stated, no, this is meant to be based on science and not based on policy. So that's when they said, all right, if they're going to do this, then we're going to remove ag use by right from the siting camps. So, I mean, that's a whole other can of worms. I didn't mean to really go down that way, but to understand how some of the history of what went through and how some of that language there still exists, I bet you it's not going to be there next year.
So if I have less than 50 animals and I can request this site review and verification and do all the things that I need to do to get the rights and protections of the Right to Farm Act, or I can choose not to do that, just like everybody else.
You nailed it. That's exactly it.
Which would then make you have to follow whatever the township's ordinance said. So there would have to be a township ordinance that, in order to govern whatever the potential nuisances of those animals were, correct? That would be on us as the township.
If they're not in conformance or did not go through the process, choose to.
Right. Then the only way that we could enforce something as a township is if we had an ordinance, because then they would not be subject to the right to farm guidelines.
I mean, you guys are lucky enough to have that language. You look at some of our northern counties where they're unzoned, you know, it's a much bigger problem up there.
And my other question was, can a small farm or farm operation that has no intention of being commercial, can they go through the GAMS? If they approached you and asked for a site review, would you say, wait a minute?
No, absolutely. That happens all the time because we don't determine if they're commercial. I do not have that authority. But I do politely tell them, especially if it is obvious to me that your 3 chickens are for you and your kids. Like, hey, you know, so you know, right to farm is the affirmative defense for the commercial production of farm products. If this were to be brought into court, or the township wanted to take you to court and challenge you, saying you're not supposed to be here, you're going to have to prove to a judge. And there's a big difference between holding a QuickBooks and having a napkin agreement with your neighbor. You have to be able to convince the judge that you are commercial by nature. Now, yes, as we already discussed, there is the 2005 Shelby versus Papish that placed the bar very low. But in my mind, there still has to be documentation.
I have one more question on
Fire.
a different topic, and that is, I saw there's other GAMs that talk about what you can't do in a wetland or in a floodplain or in all these things. And so, do you check those things as well?
As they apply, absolutely.
And if we have special ordinances for our township about surface water setbacks, it seems like you're saying that the GAMs apply. What if ours are stricter?
If there's a language in the GAMS and they're found to be in conformance with that language, it would preempt the township language.
And if there's a state program like the Natural Rivers District that requires certain setbacks that are greater, then that would still apply?
Yes, because we do not preempt other state, federal statute standards or regulations. It doesn't necessarily mean that we know about it, though. And that's part of the, like, that is up to the producer, that's up to the farm to, I mean, you can't go 15 or 35 and tell the officer, I didn't know. Like, he doesn't care. No, it's your responsibility. And that'd be the same here. It is their responsibility to ensure they're meeting all other state and federal statutes.
So if I am a commercial farmer and let's say I'm over 50 animals, and it's still a choice of mine about whether or not I choose to follow right to farm, right? It's still a choice of mine about whether I want to go through the process of following it so that I have those protections in order. If I choose not to follow them or not to contact and not to be, not to have the GAMS applicable to me, but I am a commercial producer, then that would still mean I would have to follow whatever ordinances the township set out for my farm. Correct? If I choose not to follow right to farm, whether I'm commercial or not, then the requirements are the ordinances the township has set up.
I had to think my way through that because there's a lot there. Yes, I believe so. Of course, it's always at the whims of the judge. You know, I've been in court more times than I care to say under oath, you know, and I have seen times where I thought, no way, the farm doesn't have a chance. And the judge went, oh, right to farm? Case is finished. And I've seen other times that I personally was the inspector that went through it. I knew they met it. I knew they met the language. They were meet verified. They've gone all through all the things. And the judge said, you know, no, and didn't give them the protection. So judges are a fickle thing, which is why on all this I keep pointing back to, it's up to the judge and it's up to the court.
I reserve my questions to the end, but I just wanted to get one clarification for everybody's benefit. So when I first started, when I'm not up to speed on, you know, the whole terminology, I've used right to farm and GANs interchangeably, but they're not the same.
That is correct. The Right to Farm Act gives the Commission of Ag and Rural Development the authority to adopt and maintain the generally accepted ag management practices, which identify and describe those management practices to mitigate nuisance conditions.
He's timing me. I just wanted to make sure everybody understands that, because when, let's say you have, like Kay was saying, you have something that is GAM certified, doesn't mean it's automatically protected under right to farm.
Exactly, correct.
Aspect that needs to be determined.
Yeah.
And just because it's GAM certified doesn't automatically mean it preempts the local ordinances, because the commercial aspect still needs to be determined. So I just want to make sure that we're all on the same page, that right to farm and GAMs are not the same thing.
I think that's what they're on.
Right, and GAMs are optional. That's why most of them determinations are either proactive or via complaint. But can local communities require GAMs?
I would leave that to your local legal advice, because I struggle with it personally.
Because that's not conflicting with yours, right? Because you said if you have a standard in GAMS, then we cannot have anything that's restrictive than that. But we're not,
Just read, the GAMS can change every year, and they do change every year.
right, so it's not, we're not citing standards, we're just saying get GAMS certification, make sure you're GAMS certified.
And Mike's got 6.
I would tell, yeah, I would tell you that's not uncommon. I have seen that language across other township ordinances across the state. I would also tell you, I would ask your trusted legal advisor, because GAMS being requiring a voluntary thing, I don't know how that works. I'm an engineer, not a lawyer.
Well, the flip side of that is, don't we want our ordinances to be so clear that somebody could understand what they need to follow them? And if we open up the GAMS and read them, I'm not entirely sure it's super clear to me what that means.
So
All the time for everything.
this really doesn't fall under me. I would tell you to reach out to Ryan Coffey Oak at Michigan State Extension Land Use Planning, because he does a great talk on this, but let me summarize basically what he says. There you go, it's not coming out of my mouth. You can put down whatever you want in your ordinance. It's whether or not you can enforce it. If they're in conformance with the GAMS, then that preempts local control.
If it's a commercial operation.
I mean, we look at every operation, but that, yeah, there's that second aspect, yeah. And you have somebody in the crowd that's losing blood.
You have a planning commissioner behind you, Jen.
Oh, I'm sorry, Julie.
Just clarification, we keep talking about 50 animals, but that's 50 animal units. right?
That is correct.
That's 50,000 pounds.
50,000 pounds of live animal weight, which and the reason why we do that is because there's a big difference between 50 horses and 50,000 chickens. You know, you can't, but how do you do that? You know, so we can't go through and just say you can have up to this many chickens, but it's different with horses. So, and again, as I was stating earlier, our language has to apply to Menominee and Webster. So how do you do that? So it's a way to try to standardize it across the state. Is it perfect? No. Does it need to be fixed? Absolutely. But that's something we're constantly talking about and trying to figure out, okay, based on science, based on standards, based on research that's out there, what is that line? And so that's something we talk about quite a bit.
So if I was understanding it, but then you just said something, so I thought that local governments should not attempt to regulate anything already in the GAMS. And then we just talked about, could a local township say you must do the GAMS? But that's stricter than the right to farm. The right to farm gives you that option, it doesn't require it. So isn't that exactly going against what we just said?
Yeah, that's why I prefaced this with, this is his words, not mine. It is tricky, that's a nuance there that is really difficult to navigate. And that's why I think it always comes back to wherever there's language in the GAMS and they're in conformance with it, you can't enforce it. I think that's where the delineation really applies. Because that's also where we get the issue, and it's up in court where the township says, no, we're gonna go through and do this because this is what our ordinance says. And not understanding the preemption language in there with a determination made.
One other question, Lima Township near us. So a lot of the townships have a short list of guidance for if you're not a commercial farm. And Lima Township, they call theirs suggested animal densities for good neighbor practices. And they say they got recommendations from the MSU extension. So have you seen things like that, suggested versus required in ordinances, local ordinances?
Have I seen that before? Yes.
Does it work? Any comments about, or you're not?
I have seen things all across the state in so many different things that doesn't work. I don't know. I couldn't tell you. It really depends on your people and your township. And I mean, I've seen some extremely restrictive things that apparently work, and I've seen completely unzoned communities with lots of problems. So it's really tough to be able to say, does suggested practices work? It depends. I mean, yeah, that's tough.
So we once had a discussion, a committee, about animal units.
Use the mic. Yeah, use it.
I can repeat it as well.
Hello, can you hear me?
I can hear you, but I can also repeat the question for the people behind you.
Okay. We once had this discussion about animal units. And can you tell us the history of animal units, how MDARD actually goes through a selection or goes through one of the GAMPs and evaluates how many animal units are on this property? Because I imagine you probably don't travel with this scale. So can you tell us about the history? Is it still useful? Is it outdated? Do you actually use it? Should we be thinking about it?
So Connie's question for those in the back is about the delineation of animal units in the site selection GAMPs. How did we come up to the scaling and what's the history and do we still use it? Oh, Connie. I was waiting for your questions and you did not disappoint. So the history of where animal units is really complicated, and I would say it actually started with the top, about the 1,000 animal units. And the reason is because that was the delineation that DEQ at the time utilized for their permitting process. And then they went through and then broke down from that 1,000 animal units and then started making different trees and identifying where the common practices would change. And you're no longer seeing operations with 1,000 animal units on a dairy is typically 400, 700-foot freestall barns, I think. When you get down to, you're down to half of that. So the nuisance potential is reduced. The sizes of the storages is reduced. So that's a quick and dirty where that came from and how that delineation came about. Yes, we absolutely still use it. I mean, that is the corner, or that is the framework of this setback requirements. The neighbors within a quarter or half mile is all based on those delineations of animal units. And he asked the question that pains me a lot, does it still work? We're working on it. I think that's the fairest answer. It's something that we're constantly discussing. Is this the best way we could be doing this? What else is out there? The problem is, if you guys really want to get into the nitty-gritties, it sounds like you do, there's nowhere else in the state that has a right to farm program as funded and as used as ours. Every single state across the country has a right to farm act. It exists everywhere. But nobody else is as big as we are, which is frightening, as you just heard me say earlier. I got 5 people to handle 300 different on-site requests, many times 5, 6 different visits for each one of those. I don't have the resources to barely do what we do. How the heck do they do it? Well, from my understanding, across other states, it only comes up when it reaches court. And then it's all used by a judge. So I don't have much of a framework to be able to base this on. I don't have any wheels that somebody else already did. So I'm constantly clawing, scratching, screaming, bleeding for research across other states. Where does the mitigation lines exist? Where does, when you change what you're doing in the operation, change that nuisance potential, and what technologies are out there that we can help point to adopt? And then how do I do this for chickens and dairy? So, yeah, Abby.
Since you brought up chickens and dairy, I'd be real happy if my neighbors had 50 dairy cows, but not so much if they had 5,000 chickens. I don't see how animal units are overly useful.
And you just identified the choke point on how do we fix that. We agree.
Each little menagerie of animals that you can have, and then you have to come up with a formula. If you've got 45 dairy cattle and 200 chickens or whatever it is.
The part that you got to remember when I talked about the history before is that you never looked at the small operations. So all of this was written without the intention of our backyard, our small operations. So then, because of the push that we talked about before, and now we have to look at that, the framework wasn't built for it. So now we're trying to push that square through a round hole, and we're getting that through, and it wasn't built that way. So you nailed it, my friend, and we know that. We're looking at it. But as I just said to Connie, where's the science and research out there to try to help fix it? Because I refuse to pull a number out of the sky and put it on paper or let any committee go before the commission and do the same. Because it's not defendable. Because this ends up in court.
Well, what about the 250-foot circle? That doesn't, there's no science behind that.
No, there is. It is. It's based on odor modeling, and that predates my time. I think that was back in 2000 when that was done.
It's a big difference whether it's a big operation or a dairy operation.
Absolutely. And that's where the odor model comes in. When you go through and actually look, you can find it on Michigan State University Environmental Offset Odor Model. It's on the website, everybody can see it. They actually use an odor control number, and the number for hogs is actually substantially larger than it would be for chickens. And actually, that also is a bit of an issue because the number for chickens is so small that it barely encapsulates the whole building. But the number for hogs is so big that it's a huge difference. So that's actually how we, the difference between.
You had brought up the manure plans and stuff. When you're looking at those kind of things, and if they have more animals or units than they can actually dispose of manure on the site, and you were talking about 1 year of holding it covered, et cetera, do they have to, or does the property owner have to have a thing of getting rid of the excess manure? How is that figured?
Great question. Yes, absolutely. Part of it is going through and identifying in your manure management plans, you have this many cows, let's say they produce this many cubic yards of manure. You're adding this many yards of bedding waste, you're adding this many yards of runoff. That gives you your total number that you're producing. From that, they're supposed to go through and test it. This is the nutrient value of what that is in your bin. And then, as we talked about earlier, you've got your soil test, you've got your crop plan, and then you're applying manure at a rate to meet those needs. If those numbers don't add up, you're not in conformance. So they got to make the numbers work. Now, in practicality, how does it actually happen? Joe across the street is gonna buy some from me. And he doesn't have to report that, because that's actually considered a manifest. And no longer under his control. The part that it gets kind of funny is that if even a Joe across the street, let's say, takes the manure and then he applies it on your fields, it's still your manure, still your fields, you still have to report it. But if Joe buys it from you and goes and puts it on his fields, on his crops, then you don't. And that's actually a loophole that Eagle is very well aware of, and I wouldn't be surprised if you see change very soon.
But you would still have to register that Joe bought X amount of tons or gallons.
Under the,
whatever.
yeah, under the CAFO permit, correct? In our manure management planning, you just identify that's where it went.
And this is more of a chemical question that I don't know. If you have different types of manure, can they be mixed? So let's say you have chickens, pigs, and cows. Can that all go into a manure pit, and is there any interaction between them as far as, do they all produce methane, or is there issues with that?
Yeah, I mean, that's, you're just, there's a doctorate degree there. No, we don't typically see it mixed. It could, potentially could be mixed, but realistically out there in the field, you don't see them go through a mix because of welfare, health concerns and all that sort of thing. And plus, once you reach to that size, that you're that big, that you're doing it, you're not gonna be diverse in the different types of livestock that you're having because of the different feed requirements, the different bedding, the different, like all of those things, the management that's required to raise those animals. When you're talking about the quantity that you're doing that, you just don't typically see that. So the bigger question, the real answer is, it's not whether or not you can do it, it's the fact that we don't see it outside of our Amish operations. Though please don't ask me about that.
So when one of your 5 inspectors goes to inspect a farm or a potential farm and is looking at facilities and pastures, pastures in particular, will you evaluate that pasture if it and ask if it has a septic field in it, and then how that, if that part of the pasture that has a septic field, if that can be used as part of the pasture? Do you evaluate situations like that?
No, and I'll tell you why. Because if that is truly a pasture, then your density is such that you don't have a dominance or the buildup of nutrients. If it's truly a pasture, that nutrient is self-managed within its system. Now, if it's to the point that it is no longer a self-managing system, where the primary food feed forage is coming off the ground, and your livestock density is low enough not to cause degradation, which is the fancy words of saying, you have a self-managing, then that becomes a lot. Once you have to go through and start providing nutrients because the field can't sustain enough for the population that's there, and you have to go through and remove manure because it's building up, or waste feed and waste hay and all those sort of things, that's no longer a pasture. And at that tipping point is where you could have concerns of that nutrients leaching into the ground and all those sort of things that would cause potential issues there. But if it's a pasture, you don't see that. How often do we come across that? I'm searching the back of my head. I can't think of. So.
I think drain fields as well as wells. And this is when you start talking about a smaller lot that somebody might want to raise for their own consumption, or a farm stand that they're doing.
Yeah, I don't believe that there's any language in our public health, in our law, our public well code, because that would preempt everything in there, that requires specific setbacks from pastures. There is setbacks from livestock housing, livestock facilities, which is a slightly different definition than ours, but like barns and whatnot do have setbacks from wells in there. And it's 50 feet for private, 75 feet for public well, and then flies all the way up to 2,000 depending on if it's a type 1.
Is there anyone from the public that would like to ask a question?
Yeah. In terms of, we're talking a little bit about the letters that your team issues. Can you talk about how specific or general they are in terms of what they authorize when they're granted to a applicant?
Well, we're not going to go through and specifically identify that you were X feet away from a property line, so to speak. But we're going to go through and identify what the concerns of the complaint was and the relevant GAMPs that were reviewed in connection to it. So,
if it was prospective though, if the farmer applied for it to your office,
then we would go through and identify, you requested a review of the farm market GAMPs. We reviewed your, sales records, whatever, and your setbacks, the location, and found that to be in conformance as described.
okay, so it would be more that the farm itself was in compliance and not authorizing certain use of that farm.
No, I understand now what you're saying. No, we don't go through and exactly authorize uses or anything like that. We just determine conformance. That's the only thing that we have the authority really to do. So all we're stating is that under our review, we determined you to be in conformance with farm market GAMS. So that activity was found to be in conformance. And then it would be up to the operation to utilize those preemptions or potential protections that would apply.
Okay. And when you issue those letters, are they issued to the local municipality as well?
Absolutely. Any letters that we're going to send out, if it's a complaint, once finalized, we're going to send that to the landowner of the farm. We're going to send it to the county, we're going to send it to the township. And if there's a village, sometimes that also applies, then we'd send it to them as well. And then with a complaint, we would also send a letter to the complainant once finalized. We're not sending the complainant anything other than follow-up calls and to make sure we understand and this is what we saw. But they're not getting official documentation from us until the review is closed.
Just a follow-up on that. What if it's not a complaint? What if it's like somebody seeking your help, seeking out your help? Then are you
Proactive review?
proactively-
Yeah.
And then are you then informing everybody that they've sought this out? Once you
First submission, no, because quite often, once they submit, well, ma'am, you have a house within 250 feet where you're keeping your chickens. Do you want to continue? No. Okay, then they withdraw. If they, do, and then we go out and do it on site, then yeah, we're sending a letter to the county and the township as well, as the law requires us to. And then once an official determination is made, that you've gone through, you've supplied all the documentation, you've moved so that you meet whatever required setbacks, whatever the requirements may be, then we'll send a letter to the county, the township, and the farm. You've requested a review of X, Y, and Z. We've reviewed these things under X, Y, and Z, and we found you to be in conformance with those scans.
Sir, do you have any requirements for who enforces this? Or do you take any enforcement?
I'm sorry, to make sure I heard you, who requires enforcement?
County, township, you. That's it. Who takes enforcement?
Who determines enforcement of the GAMS?
Like you say, you have to take it to a judge. Who does that? And why?
There is no enforcement.
Okay.
It is not regulatory. It is voluntary by law and thus by nature. So you can completely choose to not do any of it, but you do so at your own risk.
And who takes it to a judge to determine commercial operation?
That would be the party pursuing litigation, whether it be the neighbor. I'm sorry?
The farm itself. The farmer?
Why would the farmer want, I guess I'm struggling to understand you now.
I'm struggling to understand who takes it before a judge to determine if they're a commercial operation.
Neighbor township.
So again, to me, it would be whoever is questioning that it applies.
only when there's a complaint, essentially.
Or, again, the whole point is about nuisance litigation. So if somebody's filing lawsuit against that operation, then they're gonna claim right to farm. So whether that's the township and saying you have to, abide by our ordinance, or the neighbor that's saying you shouldn't have cows here, In order to push that to the next point, they're going to take it to court, because it's the court that's going to tell them, you must remove those animals, or you must do X. That's the body that has the authority to do that. So it would be whoever has the concern with the operation to take that to court. Does that make sense?
So it might be the township that takes it forward.
In the township, I've had neighbors, I've had cousins, I've had mothers, I've had people driving by. Anybody. It's just how deep your pockets are and how motivated you are, I guess. The gentleman here was next.
Yeah, sure. I guess for a little clarity on that question, I guess I'll just ask you so maybe you could explain. In the case that perhaps this gentleman has animals on his property, the township makes a complaint and says he's not following GAMPS, he's not covered by the Right to Farm Act. That then goes through litigation, ends up in court. If a judge decides that he is in fact covered by Right to Farm Act, what kind of compensation is he then attributable?
That's actually a whole different question entirely. So the law actually does state, hold on here, I know, I'm sorry with the camera. I'm not used to that. Thank you. Recovery of costs and expenses. Apparently this has come up. Yes, 286, 473B, recovery of costs and expenses. Any nuisance action brought in which a farm or farm operation is alleged to be a nuisance, if the defendant farm or farm prevails, the farm or farm operation may recover from the plaintiff the actual costs and expenses determined by court to have been reasonably occurred by the farm or farm operation in connection with the defense of the action. This actually just went to Michigan Supreme Court within the last year. And if I may summarize, because I don't have it memorized yet, again, I'm an engineer, not a lawyer. I believe that it was that it isn't automatically incurred. The farm doesn't automatically receive those reimbursements. However, it is requested. The farm has to request it. So is that your question?
Basically, yes, just to show that farms can recover like attorney's costs and even legal fees in the event that they are proven to be conforming with GAMPS.
Ma'am?
I had a question about, with the animal density, I know like Webster Township is close by here, and they have a bunch of zoning ordinances related to animal density. And I just wondered if you could, what your experience with that township has been and how it might compare to like Webster Township.
Well, I'm not going to comment on my experiences with any single township, largely because I deal with so many I don't remember. What I would typically state is that is along the same language, things that would fall that we talked a lot about today with site selection and care of farm animal camps, and that if the operation is found to be in conformance, then that should preempt, and I would be very hesitant as a township to pursue.
Oh, well, they have all, like, what I was talking about is more when you mentioned the smallholder kinds of operations. They have a set of ordinances that say, on this, like, on this acreage, you can have this many chickens, this many goats, this many things. And if you have X number of chickens, then you can only have this number of goats and stuff like that.
Yep, I see that all the time.
Okay.
Oh yeah, we see that all the time, all over the state.
How effective is it?
I often tell townships, if you have a concern, file a complaint, and then we'll go out and do an investigation, and then if they're not found to be following the GAMPS, then that may uphold. If they are following the GAMPS, I would continue to tread forward very lightly.
Oh, so
They could still try to take it to court,
right.
but then if they lose, there's that whole aspect that you guys well know of having your constituents upset about all the money you spent taking somebody to court. Oh, that doesn't happen here? Oh, never mind.
I guess,
Peter?
yeah, final question for me. Does the zoning board of appeals have any authority to determine if a farm is commercial or if the Right to Farm Act is a protected for them?
Yeah, we talked about this a little bit earlier. I'm an engineer, not a lawyer, so please don't seek my legal advice, but my understanding, again, is that, your authority comes from the Zoning Enabling Act and does not give you the authority to determine if an operation is following said another state law. So I believe that because of that understanding, that determination really needs to fall upon a judge. That the defendant would have to prove that I am commercial. And then they would have to supply a determination made by the department that they're in conformance with the GAMS. And they would also have to try to show that I am producing farm products.
If I may, can I clarify, just like your reference to when I ask questions about to refer to the legal counsel? So based on my experience with other townships, because the Right to Farm Act is not, there's still, it's a work in progress, right? Not every question is answered. If the legal counsel may advise that some determinations can be made, and if disagreement happens, then you can go to the court. Right. That, because sometimes those kind of determinations can be made, and then between a zoning administrator may make the determination. I don't think this is commercial or not. A ZBA can make one as part of another deliberation. But if there's a disagreement, then you can go to the court. From what you said, I'm not trying to put words in your mouth, correct me if I'm wrong, that you don't recommend. Typically, you're seeing judges make the decision, but it doesn't mean that they cannot attempt to make a determination when required.
Possibly if that's what your legal counsel has told you, it's always been my understanding that your authority from the Zoning Enabling Act does not give you the authority to determine whether or not an operation is following other state laws. And so since that is within another state law, I personally would be hesitant doing that, but if that's what your legal, it tells you that you guys have the authority to do up through a disagreement, then I wouldn't argue with them.
That's good. So it's your understanding is the key.
I'm sorry, my understanding is what?
When you said it's your understanding, doesn't mean it's the final determination.
Oh gosh, no. I'm just one man sitting on a chair.
Okay, thank you.
I was going to say I was a second-class citizen in my own house.
So Jeff, along those same lines, then if a resident decides to use Right to Farm as a defense with the ZBA, the bottom line is that they should utilize or have a court proceeding that determined them as commercial, plus GAMS. The stuff that would recognize them as Right to Farm, they should be producing that. If not, you don't have a determination to make.
I think, so whenever someone wants to claim Right to Farm, you first and foremost need to have a determination from the department done that you are in conformance with the GAMS, because if you're not there, nothing else is going to matter, whether you're commercial or not. And as we talked about before, the 2005 Township of Shelby versus Bayfish, whether you sell 1 egg a year or 1 million eggs a day, that bar is very low. So to me, I tell people it comes down to your documentation. Do you hold QuickBooks where you track expenses and income and inventory, or do you have a napkin agreement with the guy across the street that he buys a dozen eggs from you? Those two things are very different, and the ability to defend that is going to be very different. So, but again, from my understanding, from the legal advisement that I've always heard is, you've got to prove it to a judge. So,
just to follow up with that though, if there's a complaint and the farmer says, no, I'm right to farm, and they produce the letter saying that they have, they're following GAMS, then in order to sort of go up to the rest of the argument, they can prove they're commercial right up front. They've got tax documentation saying that they declared themselves as a farm. Then that's when the zoning administrator or whoever is looking at it, and if they agree, then that's done. There's no court necessary. So it's really when the proof isn't there that the disagreement to go to court occurs, if we're pushing for that issue, right? Like, that's really what it is.
Yeah, if you schedule an F4, I experts.
I mean,
documentation.
sometimes it's really quite obvious, right? It's not,
Yeah.
there's no debate there.
Yeah, I would say so. I love it.
Oh, I'm sorry, okay.
So just to make sure I understand, so if someone follows GAMS and they can prove that, then they do not have to follow any local ordinances. And the right to farm is something higher that provides them with other additional protections. Is that true?
Wherever the GAMS provides specifications. So for example, we have language that tells you where you can have livestock, but we don't have any language that says that that building has to match the house, which is something you typically see in townships, or has to be the similar construction materials, or lighting. I don't have any language that discusses lighting on that barn. So there's, just because the ability to hold livestock doesn't mean that the township doesn't have any say in how that's being managed. It just means that wherever that there's the description on their having livestock under the GAMS, and they're bound to be doing that, that would preempt that local ordinance.
If they have right to farm, they are still.
That's my question, because they don't have to have the right to farm, all they have to have is their reputation, they're following the GAMS. Or the right to farm is more, do they have to have that?
So they have to be a farm, they have to be.
I think you're right.
Production, producing farm products, they have to be commercial, gas compliant, then they're protected under the Then they.
Connie and I, guys, have gone back and forth on this over and over again, and the language I'm gonna read to you that I read to her is the legislative intent that this act preempt any local ordinance, regulation, or resolution that purports to extend or revise in any manner the provisions of this act or the generally accepted ag management practices developed under this act. I read or. So how that goes through, I'm hesitant to continue down the conversation because ultimately it's going to be up to the whims of the judge and how they decide to interpret it. And I don't know what precedent exists out there and how that has been interpreted. Just because there's been a court case with right to farm at the local circuit court level, it doesn't always make it to my desk that it happened. So I couldn't tell you how that's always been interpreted. Sorry, Connie.
Okay, so it's clear that the Right to Farm Act, and you deal with the program, you're MDARD, you deal with the program manager. There's so many nuances to the Right to Farm Act. And some of these questions they're just nuanced. And we can't all be expected to know the nuances, and neither can you. So there's the other group, VMSU Extension Service, that is well versed on these nuances, that is probably could offer a little bit more clarity because that's what they focus on. You focus on GAMS. If somebody needs GAMS, you help them. You don't deal with them you don't determine if they're covered by it. You don't get into the nuances of it. Basically, you are just MDARD. It's not just MDARD, but you don't get so much into the legalities and the nuances of it. You follow GAMS. You determine if follows.
Yeah, absolutely. Thank you for bailing me out of this spiral. Ryan Coffey Hogue at Michigan State University Extension Land Use Planning. He does, that she's really talking about, specializes in township planning, writing of ordinances, and he is our farm market chair. And I would highly recommend talking with Ryan about exactly, she's talking about the nuances of the meshing of ordinances and townships and how you guys under your authority of the ordinance, Zoning Enabling Act and the right to farm. Because obviously, absolutely, my world is right to farm. I see everything going on over there, but absolutely, some of those, she's talking about the nuances, I would highly suggest reaching out to someone like him to try to help you guys navigate that to the best of your ability. Because I admit, it's hard.
Clarify one thing. When you do a site visit, or one of your do a site visit, and they state that the farm is in compliance with GAMS for whichever
camps we're talking about, that means that they are that day. Isn't it the responsibility of the landowner then, anytime they change anything at all about their situation, that they need to notify MDARD and have a modification of their evaluation?
If they're looking for that conformance determination, I guess you could say that. Realistically, it's when a concern arises. If somebody has a concern about something that's being done on that operation, then either the township or the neighbor or somebody driving by would file a complaint. And then we go out and do a nuisance investigation for conformance, for determination of conformance. Realistically, it's, we don't see anybody. Oh, I added 2 more chickens. I want another review done. I'm moving my newer file from here to there. I want a review done. That we don't see that. But in a way, you're not wrong. It's just not really how it was built, and nor do I think that it was the intention.
So I think we've lost sight of the law. I think the purpose, I'm an old guy, so I recall back in the 60s when Michigan Farm Bureau was pushing for a right to farm law, and it took another 20 years or whatever to actually get it adopted. But the thought process was if a farm was in existence and they were doing things correctly, that they should be allowed, if they need to run a tractor at 3 o'clock in the morning, and it's got a turbo on it, so they want it unmuffled, that they should be able to do that. Because the new subdivision went in next door, they shouldn't have to go to court and spend tens of thousands of dollars to defend running that tractor at 3 in the morning. That was the initial push for the right to farm law, and GAMS hadn't even been thought of.
Yeah, no, absolutely. I mean, GAMS came across over the years, like our very first one that I just pulled up. 1988 was manure, it was the only one. 91, pesticide. 93, nutrient. 95, carrot. 96, cranberry, that's a whole other story. 2000, site selection. 2003, irrigation. 2010, farm market, and now finally here we are, 2024, going into 25, greenhouse. So I think you're absolutely right, that in many ways it's not what it was when it was introduced, but it also, I believe, that it's intended to be adaptive. As things continue to grow, more people are here, less farm space, more interaction, it's forced to grow and adapt. We've got somebody in the crowd.
I have a hypothetical. Okay, so there are these planned use developments, subdivisions. Some of them have very large lots. Say you have applied with, 3 to 5 acre lots. And someone, decides to purchase the property and then start a small farm on it and conforms to GAMS in keeping stuff away from their neighbors, like the 250 feet from their house. And the lot's large enough to accommodate it, as long as they're conforming to GAMS, can they overcome the limitations that the PUD places on them? Oh, you've got to have this, you've got to have 2.5 acres of lawn and all this. If they decide we're going to use the right to farm for this lot, and our house fits.
So that really is case by case basis, and we don't preempt other state and federal statutes. So when you get into some of those certain building associations, that's beyond my view and scope, and there's things that apply there that they would still be beholden to. But yeah, absolutely, we see that from time to time, where somebody that wants to have it in an area that you wouldn't historically think of it like that. They place them in the exact spot on the lot that they're able to do it, so they're within the setbacks, and they manage the manure in accordance with the manure management camps so that they're able to meet the setback. Absolutely, we see that.
So they would be able to use that to overcome what do you call that? It's
HOAs.
the bylaws of the.
Well, and again,
Association.
that is beyond my knowledge base. Like, if there's other state statutes that allow HOAs to be able to do that, it may
Well,
not
and if it's
that,
an
so-
HOA or a PUD, you might be signing a contract to conform to those.
Oh, it's a deed restriction?
Deed restriction, so the answer is no, you can't do that. When you sign off on that deed restriction, and you're now legally bound to that HOA.
There you go.
Everybody in the HOA is giving up their right to
No.
farm when they sign the
They
document?
sign certain conditions
Right,
in that area that they will abide by.
but they
And
can't
that's-
use right to farm
No,
to
they
undo
can't.
that?
No.
It's a legal contract.
Yeah. Well, I mean, they're legal contracts, but then
No,
you
this is
can, yeah.
not in this case.
Okay,
Okay.
Even if you have a rural residential or an ag area with lots of 5 or 10 acre lots, you still have to do the site selection categorization, right? And determine how many neighbors you have. So if you have too many neighbors, even if you could meet the setbacks, if you have too many neighbors, you'd be in category 4.
Yeah.
And then.
The first question to get down that is, and I apologize for interrupting you, how many animals you got? Because that's what's going to determine the next step. So if you just have a couple backyard chickens or a couple hogs, then it's just going to be that 250 feet, 660 for 13. That's it. It's once you reach those larger animal unit groupings that you're going to have to start looking at a lot of other things. It gets a lot more complicated. And the man behind you.
Oh, I hadn't raised my hand, I'm sorry.
Oh, then
oh,
to the odor and manure management, you talked about number of cubic yards and testing the nutrient. Who does that? Is that something that the township could put in their zoning ordinance?
I would be hesitant to do so because the GAMPs do describe the manner in which that is done. So I would be careful.
So GAMPs test that.
GAMPs, it requires that the testing is done in order to provide nutrient values for application. And it goes through and talks about, as I did earlier, about how you can go through and apply it to meet crop needs and all that. The problem is that you're really getting into, there's no hard, fast, set number. It is completely dependent on your soil type, on the crop that you're growing, its yield. You know, the yield of crop that you're getting down here is going to be drastically different than Schoolcraft County. You know, they've got 3 days to grow things. You know, so there's no hard, fast number of that. So to answer, yes, that is something that's addressed under the GAMPs. They need to be able to do the testing. I don't do the testing. They go through and send that into a laboratory to be done, and it's often done by a consultant.
I just want to go back and ask you to clarify something, because Kay asked a question about GAMPs, and if they're just covered by GAMPs, then they don't, then that supersedes the ordinance. And I don't think that's true based on what I'm reading, so I just want to see if I'm reading it correctly. So the conditions are that a farm or farm operation shall not be found to be public or private nuisance if the farm or farm operation alleged to be a nuisance conforms to GAMPs. That's what it says.
Yep.
Okay, but then I have to follow up with what is a farm or a farm operation. And the definition of a farm or a farm operation is that it's commercial production. So just saying that they follow GAMPs doesn't mean it supersedes local ordinances unless they also are commercial operations. So it's still, they have to be right to farm completely to supersede local ordinances. Am I understanding that correctly?
That's a fair argument. And again, I would say and it's exactly just where you're into the weaving, networking, and you guys, I'm doing this from memory, aren't you impressed? That resides, and I, from my experience with that, ultimately it's going to be up to a judge, because I've seen judges do wild things. So yeah, that's tough. I mean, I don't have a great
But I
answer.
don't want to put out there, all you have to do is meet GAMPs, and then you don't have to follow our guidelines if we so set them, because that's not necessarily true. That would be up to a court, right? If we disagree, if it wasn't resolvable between the parties, then it would be up to a court to determine. Yeah.
Peter?
Yeah, I guess so listening to this conversation, and I guess with Mr. Kingsley's comment about how back when the right to farm was originally being drafted, it was meant to prevent farmers from getting involved in costly litigation. So I guess I've heard you say quite a few times that this always gets left up to a judge. That's also a costly endeavor potentially, just deciding if a farm is commercial. So why isn't it in MDARD's and the Michigan Right to Farm Act's best interest to have some kind of language that more specifically defines, or at least highlights, this one judge's decision as stating what commercial farming is, so that it doesn't have to be something that ends up in the courts costing either a farmer or the township, for that matter, thousands and thousands of dollars in litigation fees?
I think that's a great question. To be completely honest with you, that answer is way beyond my pay grade. I couldn't tell you why we don't do that, besides the fact that the law states that my authority is to determine conformance and to facilitate the annual review. So, yeah. You know, I agree. Why doesn't it do that? I don't know. It doesn't. And it, you know, frankly, it was before I was born. So,
Mr. Wozniak, my understanding of the way that the Right to Farm Act interacts with local ordinance is that townships and municipalities can have any laws that they want to draft or write, and that they apply universally to landowners within that township. But the Right to Farm Act creates an affirmative defense. And what that means is that the landowner would be in violation of that ordinance, but they would have an excuse to be in violation, and that would be in the form of the Right to Farm Act. If there was any kind of discrepancy or a dispute that that property owner did in fact meet the Right to Farm Act criteria, then they could elevate that to a judge and make a further determination, either in favor of a letter being issued or saying that they are in fact not in compliance with the Right to Farm Act. And then at that point, enforcement would fall under the ordinance of the local municipality. Do you feel like that's a fair characterization of how the interaction would be?
I mean, gave you a lot to think about there, but yeah. I understand everything you just said. Yes, I think I would agree with that.
I'm looking for a motion. Oh, I'm sorry. I was going to cut you off.
No, I just wanted to wait until everybody's done.
Oh,
Just
here we go.
No, I'm ready. This has been great.
I can call Mike individually. I was just going to ask questions so that everybody benefits from the answer. So these are pretty good questions because I've had them. Do you verify conflict for pasture locations with well and septic fields?
Do we verify locations?
Like if there's a conflict, if a pasture is located, if a required pasture area or part of it is located on well and septic?
No, we don't. There's no language in the camps that requires setbacks for pastures to well and septic fields.
So we can't hear your question.
Thank you. Oh, I'm sorry. The question she asked is, do we verify setbacks for pastures for well and septic fields? And I said, no, we don't have any language that requires that sort of setback. And furthermore, setbacks from under the well construction code, and that falls under DEQ and are a given authority to local health departments. So those sort of setbacks would fall under that. But because you specifically mentioned pastures, no, I don't believe that any setbacks exist.
Because from what I learned, cows and pigs can be heavy.
Yes, cows and pigs can be heavy.
As part of your discussion...
Sorry, that was funny. That's the first time I think I've ever said it. For my word, cows and pigs can be heavy. Yes, yes they can be. Some dairy cattle are north of 1,600 pounds.
How many animal units is that?
My friend, you just nailed the problem.
As part of one of your responses, you said holding capacity is what kind of determines how many animals you can have. So that means even though, based on your acreage density requirement, you can have up to 60 animal units, the holding capacity can bring that number down. Up.
Depending on the management, yes. I mean, you really are getting into a whole other academic discussion that it sounds like we're not getting into, but there's a whole, there's all kinds of guidance out there on square footage per animal from different institutions that we often do refer to depending on how they're managing that. But again, like, there's a big difference between a freestall barn and a lot and a pasture. And that pasture, I'm gonna be asking for some sort of grazing plan that identifies what sort of yield are they getting off of their desired, crop mix, and how many, how many pounds a cow really eats a day, and you guys are getting into things that I did back in consulting. But like, there's a big difference as you get across that. So yes, we go through and do that, but there's no hard and fast number.
I have 2 more.
3 minutes.
So you've also said in one of your responses that, the animal unit, in response to Connie's question, that animal units is a work in progress, you're working on it. It's not,
Yeah, I'm sorry, go ahead.
And it's also for a normal person who's not in commercial farming, understanding animal units and how it works might be a green light. So would you recommend, if local townships are writing their ordinances, to refer to animal units for non-commercial operations, because it's a complicated calculation?
I would not make any recommendations on how you write your ordinance in any way, shape, or form, but I would state that the GAMS are always under review and subject to change. And that is just one topic of many that we are constantly reviewing and trying to figure out, is this really the best way to be doing this? Is there new research or standards out there to be able to refer to? And that's regardless of the GAMP, everything, well, besides cranberry, that's a whole other thing. But, manure, we're doing that all the time. And in irrigation, we're doing that. What's the new research and science that's out there? We're talking quite a bit about, not to bug you guys here about this, but down in Dundee, Michigan, they actually have an issue where the groundwater itself is full of sulfur. So when you're irrigating sulfur-laden groundwater, it stinks. So we're trying to go through and figure out, how do I mitigate the odor, because that's a nuisance, from just using the groundwater on your crops? So we're talking about all kinds of things of irrigation. They're dropping the nozzles, using bigger droplet sizes. Are you some sort of buffers between that and residential areas? That's just this one topic in just irrigation. So when you're asking me about animal units for being subject to review for your ordinance, I'm telling you, I would be hesitant to use any specific language from any of the camps because it's always subject to review.
Thank you. I think you've answered my question.
Sorry.
I think there's a Dundee joke in there.
There was.
Then the 250 feet radii, you said that kind of came before you, but that must have come with a reason, right?
Yeah, no.
To prevent the nuisance odor and such?
Yes, I believe it was, I didn't ever catch your name. John, it was in response to John's question. He said he had brought up, and I apologize if I'm misquoting, that there wasn't anything behind that number, how that number just was arbitrarily came up. And I described, no, there is some history to how that number was developed. And yes, it was before my time that I joined. But I was taught, and it's my understanding, that that is based on odor modeling and certain setbacks that reside within that. Now, all of that research I'm not going to dive into here today.
Oh, no, I'm just trying to establish the fact that there is a reason why that number exists.
Yes.
And when you're drafting ordinances, it's probably a good practice to follow a certain radii rather than, a non-commercial animal keeping.
Yeah, you guys, you can establish your ordinance how as you see fit.
I think that was it for now. I know where to find it.
Absolutely, anytime.
Yeah, is that your cell phone?
Yeah. Yes, this phone right here. Yes, it is. Sometimes I answer as right to farm program manager. At this hour, I answer as spill response coordinator. And if there's a major fire, I'm logistics section chief.
I'm looking for a motion to adjourn.
You have one question behind you.
Oh, I'm sorry.
Yeah.
I was just ignoring you.
I guess this is a two-part question. I'm just curious if you happen to know what your current budget is?
tell you, am I still being recorded?
Yes.
I believe that once you take off staff expenses, I have like 13 grand a year to play with.
If we were interested in advocating for an increase in that budget for your program to bring on new inspectors to increase your ability to do your job, who would we talk to?
I would buy you ice cream. I've actually been before Director Boring many times asking for a full-time equivalent. So as we talked in there, I'm sorry, here we go, you're trying to get out of here, I'm getting back into it. So we're responsible for doing two things. Investigation of complaints for conformance with the GAMPs, and then facilitating the annual review. If I were to show you a map, I've got 5 people that go out and investigate complaints. You know how many people I have that's facilitating the annual review? You're looking at them. So I've been begging, pleading, crawling, scratching, crying, bleeding, asking for somebody whose job is just the GAMPs to help go through and review the language, facilitating these meetings, reviewing the languages that are going in, so I'm not staying up all night doing it.
Well, you got a captive audience, man. Who do we
I
call?
know, right? I'll take $1. And then on top of that, requesting funds to be able to have grant technicians that can apply for like a part-time gig, and their job is just to scour the globe for updated research for each one of those different camps and to help facilitate where those things come and where they might be identified. Otherwise, right now, the responsibility falls upon the advisory chairs. As we stated previously, that they are appointed by the dean. So these are current employees within Michigan State system. Not paid extra to do this. So, yeah, I would love if you told your legislature, and I'm sure my boss is going to kick me for saying this under a recording, and tell them to, hey, continue to support MDARD and the Right to Farm program for the great work that they're continuing to try to do.
Yeah. Given your busy schedule, I'd like to thank you for spending time Saturday afternoon with us. It's been tremendously helpful and informative. Greatly appreciated.
Thank you, you guys, it's been a pleasure.
I move we adjourn.
Is there a second?
Second.
Those in favor of the Township Board adjourning this special meeting, signify by saying aye.
Aye.
I have a motion to adjourn. Second? All in favor? Aye. Opposed? Planning Commission meeting is closed.
CBA, members, just looking for a motion.
Motion to adjourn?
Second.